JKLive, powered by Samsung S24 Ultra. Now, let me introduce you to something extraordinary. The AI-powered Galaxy S24 Ultra. And this is not just an ordinary phone, it is a revolution, a journey into the future of mobile technology. With the new Galaxy S24 Ultra series, you can now circle to search for travel destinations or search for products while shopping online. The Galaxy AI in the S24 series also has the live translate feature, meaning you have a personal translator in your pocket. And that's not all. The Galaxy S24's new AI camera comes with a slow-mo recording feature. And you also get a powerful AI tool for adding or editing out content from images. Get yourself a Galaxy S24 Ultra available across the country and join the artificial intelligence revolution. Time for the bench. My guests have been sitting patiently because it's a hot topic, folks. The boss herself, Gladys Boss-Cholet, Deputy Speaker, National Assembly, and Dr. Otiende Amolo, MP Rarieda, Senior Counsel as well. Folks, karibu sana.
Thank you.
Good to see you guys. Let's get right to it, boss.
Yes.
This seeming civil war between the judiciary, the executive, the legislature, what's going on? Is this what the Constitution anticipated?
Okay, first of all, Jeff, there is no civil war. I think various bodies of government are constantly criticized. The legislature has been criticized several times. Even us as politicians, we are criticized severally. So if someone just criticizes you, that isn't an attack. And doesn't mean that there is a civil war. And I think the judiciary should be able to embrace that. It should be a time for them to reflect and think that, you know, where are we going wrong? Do we need to change the way we do things? Are we serving the people in a manner that they are satisfied with it or not? So it should be a time of reflection. I don't think it's any criticism. Many times, cabinet secretaries come to Parliament. We criticize them. They are questioned, and they're given very hard questions by members of Parliament. But there's no time you've had the executive saying we've been attacked, or that there's a civil war between Parliament and the executive. So I think...
Senior Counsel, what are your thoughts?
Well, Jeff, it's a pleasure to be here. As you said, I was on some self-imposed sabbatical.
Self-imposed.
Well, a number of reasons. Last year, first, I was part of the bipartisan talk for some time, which I was chairing, and it was not appropriate to engage on the very things we were discussing. And then I also became the captain of Bunge FC and Madam Speaker here, and the team tasked us to practice so heavily.
So you're captain?
Yes, of the football
What position
team.
do you play?
I'm a defender, number 5.
Oh.
And I've followed all these games on AFCON.
Oh, you are? Okay.
I'm quite saddened that Tanzania has lost so heavily.
Yes.
Because in most other games, the underdogs have been winning.
Correct.
But that aside, starting with the topic, Jeff, I think that topic is ill-phrased. The sword or the Constitution. It should actually be both. It should not be either or. The president swears by the Constitution internally to defend the Constitution and the people of Kenya. He's handed over the sword for external aggression, not to use on Kenyans, but to use on those who want to attack Kenyans. So when the president says that, the sword is not for cutting mboga, that's where he starts to miss the point. That sword is to protect us from others, not to be used on any Kenyan. For all Kenyans is the Constitution. That's number one. Number two, the way you phrased it, that this war between the executive and the judiciary, there is no war. And it reminds me of, I've been watching news a lot. And the international media, especially, I don't know whether I'm allowed to mention,
yes,
but let's say,
yes, you can.
Yes, if you look at CNN, for example, reporting, when it was between Russia and Ukraine, they clearly wrote the Russian war on Ukraine. Now that is between Israel and Palestine or the Hamas, it's not Israel war on Hamas. They say the Israel-Palestinian conflict. But if you watch Al Jazeera, on the other hand, they say the Israeli war on Hamas. In our case, it is not a war between the executive and the judiciary. It is the executive war on the judiciary. The judiciary has not opened any war on the executive. Lastly, and this is where my point of departure from Honorable Sholei. It is okay for governmental agencies, the principal arms of government. You know, we have 4, okay, of state. The traditional executive, judiciary, and the legislature. But we also have independent commissions and offices who, it has been argued, can actually stand as independent organs of state. But the point is this: among these bodies, there are some which are meant to check on others, but there are others don't have the power to check on others. Let me explain. For us in the legislature, we have a constitutional mandate to oversight the executive. We oversight the executive by determining the budget. We oversight them by deciding whether the actions of the executive are reasonable or not. That's why even the president addresses us once a year. So we have that mandate under Article 94. The judiciary oversights both us and the executive under Article 165. For us, they determine whether any law we have passed is constitutional or not. Okay, they can't make law, but they determine. Yeah. For the executive, they decide whether any executive action is within the constitution and the law or not. So it's perfectly in order for them. The constitutional commissions and independent offices oversight all of us, the legislature, the judiciary, and the executive. However, the executive is not given any constitutional mandate to oversight either the legislature or the judiciary.
Okay, I'm glad you mentioned the legislature and the executive. Boss, let me ask you this. Chief Justice Martha Koome the other day said that the executive and the legislature seem to be fused, like joint at the hip. What do you say? Do you agree, disagree?
No, I think in as much as each of the arms of government are independent, they are also interdependent. Because the judiciary still, the laws that the judiciary interprets are passed by Parliament. So they just work in separate areas of each. So I think you cannot have a situation where you say that the judiciary and the legislature are at loggerheads or so on. But in as much as the judiciary, they have independence to make their decisions without any influence, without fear or favor. That's what we do when we talk about their independence. But it doesn't mean that they are beyond criticism or that people cannot make complaints when they have complaints against them. That is why we have the Judicial Service Commission, where people can take complaints to the Judicial Service Commission. If the Judicial Service Commission finds fault or that a judge has a case to answer or a magistrate, then the executive, that's the president, is the one who appoints the tribunal to look at them. And that is how the powers have been separated, so they can each check each other. But in this case, like I've said, it is not a case where anybody's interfering with the independence of the judges, or they're not trying to remove any judge from office. They're just calling them out that something is wrong. Just the way we all, any member of the executive can be challenged when people are not appreciative of what they have done. Okay,
so Senior Counsel, you're talking about the JSC. If the president has any problem with the judiciary or any judge, why can't he go through the JSC? Why can't he go through due process rather than, making announcements?
The explanation given by Honorable Sholei cannot be faulted on its own, but that's not what's happening, okay? The process of what's happening is a process essentially of witch hunting and trying to cause disaffection, not even against an individual judge, but against the institution of the judiciary. Look, there are mechanisms for checking the judiciary. I can outline like 5 very quickly. First of all, in terms of decision-making, if you think a judge has made a mistake, you can apply for review, and there are 2 kinds of review. There's administrative review or judicial review, or you can appeal. That's number 1. Number 2, within the judiciary itself, the Constitution allows you, if you think one judge is likely to make a mistake, you ask for an uneven bench. And in fact, the Constitution itself says that if it's a question that raises substantial issues of law, then it must be at least an uneven bench of 3. So that's internally. Externally, if you think a judge has made a mistake, you go to the Judicial Service Commission. And you can either do it anonymously or you can disclose. So, for example, if the president believes that he has evidence against any individual or some judges, he can do so himself, or he can cause someone else to do it, and he can even do it anonymously. The JSC can act of its own motion and investigate. Secondly, the criminal jurisdiction still remains. The president chairs the National Security Council. That is actually the closest he can come to dealing with the judiciary, because he chairs the National Security Council, of which the National Intelligence Service is part of. And one would expect, therefore, that he could get briefings which you and I might not get. But the question is, if he gets such a briefing, that briefing will not be against the judiciary. It will be against an individual judge and individual actions. So what should he do? Should we go in churches and in funerals and accuse the judiciary in blanket? No. He should do either of two things. Use that information and pass it on to the JSC so that appropriate action can be taken. But if it is corruption, as he's saying, nothing stops the NIS acting with the DCI and the ESCC from dealing with the individual corruption of judges. No judge is insulated from criminal conduct. The insulation is in terms of interfering with their work and removal from office. So if he has all this, why does he keep going to people who don't have that information and can do nothing? Yet he knows the right channel. This is not about corruption in the judiciary. This, if you focus there, you are missing the point. Did the president just wake up and think that now there's corruption in the judiciary? No. This is about trying to control the decision-making of the judiciary in view of unpopular and unlawful actions taken by the executive against legal advice. That's the bottom line.
Boss, you're getting very restless here.
No, I think people, you're trying to interpret something so technically that the only way you can criticize the judiciary or speak about the judiciary is by going to the Judicial Service Commission, and that we are gagged from saying anything at all. You know, what is being held by the president and other political leaders is a political conversation with the people. You must remember that the political leaders were elected on certain promises that they made to Kenyans. So if those promises have not been able to happen because there was a judicial decision, it's very important to go out and take that conversation back to the public. The public need to understand that the Article 43 of the Constitution obligates the state to provide affordable housing, obligates the state to provide universal health care to all, and education and so on. Kenyans need to understand that, because Kenyans will ask, why aren't we getting this? And we were promised, and the Constitution has required it. In fact, I would have expected that the state would be taken to court for not providing the social and economic rights. And again, this conversation might be told to Kenyans, because Kenya ratified the United Nations Convention on Social and Economic Rights, which we domesticated under Article 43 of the Constitution. And we are obligated as the state, and the state is the judiciary, the legislature, and the executive, to provide those social economic rights to Kenyans. So if we fail to do that, you take the conversation back to the people. And to have that conversation with the people it's a way of explaining yourself. It is the executive is required to explain to Kenyans the progress they are making in providing the needs out of Kenyans. And so there is nothing wrong with taking that. So don't tell us just go to the Judicial Service Commission. We are within our right to have that conversation with Kenyans. And it is important for Kenyans to get that, to be able to understand this. Because let Kenyans understand that the judges themselves have a mortgage facility which is paid by taxpayers at 3%. So they have housing. It has been provided for them. The judges have medical insurance covers of almost 10 million shillings and are able to be treated as far as in the UK and everywhere abroad. And so when we don't provide that for other ordinary Kenyans, we need to give an explanation to Kenyans. And it's important for Kenyans to understand that. And when we question the actions of the judiciary, again, let the judiciary use that as a reflection point. For example, I think I saw in your headline news where you're saying that the National Assembly is in contempt of court. That is not true at all. In fact, today, the National Assembly was in the court in Kisumu that had given those orders prohibiting public participation in the manner in which we had advertised. That public participation that we were undertaking and advertised for as the National Assembly was for us to undertake public participation through receiving memoranda. And that is the one that was prohibited. But at the moment, we are undertaking public participation by having public hearings. So it's a different form of public participation. And today, the judicial officer acknowledged that the National Assembly has continued to undertake public participation in other forms other than the one that was prohibited in the order.
All right.
So also, you need to correct your news.
No.
Okay, I'll let them know. I'll let the editor know.
Yes.
No. You do not let the editor know any such thing, because you are right. But let's go back.
No,
there's a question.
They were in court in Kisumu.
Yeah, there's a question you posed to Madam Shulei,
yes,
about the CJ commenting that the legislature and the executive are joined in the hip.
Correct.
And Madam Shulei didn't answer, but I will answer. The truth is, the answer is yes. Don't look far. Madam Shulei is the deputy speaker. She's the deputy speaker.
Yes.
And she's telling you that it is within our rights to question. She has uttered the word "we" like 8 times. Is she speaking for the legislature or the executive? The debate is about the executive and the judiciary.
No, political leaders.
Madam Shulei have known for so long.
Political leaders have spoken about
She's a brilliant lawyer,
yes,
and a very reasonable person. But she has drunk from a poisoned well. And that well is poisoning her mind. So that she has even forgotten that we elected her as the deputy speaker of another independent arm that is supposed to check on the executive. And she is now coming to do what you'd have thought the Attorney General or somebody deep in the executive would be doing, defending executive action and utterances. Now, it is totally wrong. Let me explain. First of all, let me just explain. You know, Madam Shulei says that the executive made certain promises, and therefore they must keep them. This is not about who made what promise. And nobody is stopping anyone from making any promise. It is not even the mandate of the judiciary to question the policies and promises made by this regime. The only thing the judiciary can do, and that's all they have done, is to ask, is what you are doing constitutional? Is this also being done constitutionally? The very things that now is making them lament, which is the health laws, amendments, the affordable housing thing, Madam Shulei knows. On the floor of Parliament, I pointed out the very things that the court now pointed out, okay? And I even told them that I am not in that regime. But assuming that's what you want to do, please do it legally and lawfully. Please make sure that you cannot go and start taxing Kenyans without a legal legislative basis. Because the Finance Bill and Act is not a basis. That is just designates the process. There must be a legislative basis. That is what the court told them. That is what now they're trying to do. They could have done it then. So it's not about determining for them which policies. Look, we've heard from this same regime that they will only give employment to those who voted for them. Well, that might as well be their policy because no one has denied it. Do you think that policy can stand the test of legality in court? Of course, the court will say no. The court will say the Constitution abhors discrimination of any sort, including on political grounds. So such a policy will again be struck down. So instead of looking at where the problem is, which is this, we have a regime that believes that it can impose its will on Kenyans and cannot be questioned in terms of reasonableness, cannot be questioned in terms of constitutionality, and anybody who dares do that then is against the people. That is just wrong. The executive must understand that they have no superior authority over the other arms. Under Article 1, only the people are sovereign. And in fact, if you look at the hierarchy, it is Parliament that is mentioned first, then the executive, then the judiciary. There is no way and no basis on which the executive can believe that it can now impose its will on the judiciary or the legislature. The fact that they've succeeded in doing it for the legislature is courtesy of the leadership we have in the legislature. But I'm glad that the leadership in the judiciary is resisting that takeover. And I think and I applaud you. Now, coming back to whether you should correct, you should talk to your editors.
Yes.
This is splitting hairs. I am not aware of what happened in Kisumu today, but it's very simple. Where the court says that Parliament cannot undertake public participation, because that's usually the word. Public participation comes in many forms. It comes by way of written memoranda. It comes by way of oral hearings. It comes in many forms. Some even just send emails. It's public participation, and all of it is always in a report. Where the court has said that public participation should not be held, and then you say the court only talked of receiving written memoranda, not hearing.
The judgment
it is outrageous. And if that happened, Jeff, then they are succeeding in intimidating the judiciary, which is their entire intention. No interpretation can say that you can now go and be heard, but you cannot submit something in writing, even if you have summarized it in writing. That's just a distinction without a difference.
No, but let me read for you the exact reading of the judgment, that the ruling that was given when they issued the conservatory orders the first time on the 19th of December. It says, in the interim, conservatory orders be and is hereby issued to prohibit the conduct of public participation in the manner prescribed on the 9th December 2023 in the local dailies until the application is heard. So
that's my exact point.
So now public participation is continuing, not in the manner that had been prescribed in the 9th of December announcement, but a different format. And today the court in Kisumu has acknowledged that, and they say there's no problem.
Okay.
With that public participation continuing.
Okay.
Yes.
Let's take a break.
Yeah. Folks. So you cannot overinterpret the judgment. You can't make your own interpretation. That is the interpretation of the judge.
Splitting hairs. The essence is public participation, and either it is stopped or it is not.
But you're not.
When you are conducting a hearing, yes, and somebody like you, Jeff, you come with something written. Yeah. Yes, and you explain it in summary. And then you say the full dossier is here. How will I tell you that you cannot submit what you've actually just summarized? That's just nonsense.
Okay. What Honorable Otiende Amolo is doing now is he's trying to write his own judgment. On the one hand, you have just told us that we must obey court orders. So you must also follow what the judgment made. You cannot now sit here and write your own judgment and begin to tell us what we should do. You're not the judge at all in this
folks,
case.
Let me take
and
a break
also,
here.
it must be remembered that Parliament has obeyed the court order. They have put in an appeal. They did not. They are not in contempt of the court order at all. But you are making an extension.
If they have obeyed, why are they appealing? You can't obey. You can't appeal what you've obeyed.
No.
You see, it's very simple.
Okay. On that note, let's agree to disagree for once and take a break and talk about the president and opposition leader are in disagreement when it comes to dialogue with the judiciary. Why? Why? Shouldn't there be some kind of dialogue? One side says yes, the other side says no. What are your thoughts? What are your thoughts? Keep tweeting at Koinange Jeff. This is a brilliant conversation with two brilliant lawyers. Ooh, I'm getting an education here in jurisprudence. Is that what they call it?
Absolutely.
Oh, thank God I got it right.
And he's trying to write his own. He's now made himself the judge.
Judge, jury, and executioner.
Exactly.
Keep tweeting at Koinange Jeff at Citizen TV Kenya. The hashtag is JKLive. JKLive takes a break. We'll be back in a moment.